As you know, we are welcoming our first scholar in residence for the Center for Innovation in Business Law and Technology here at Touro. And I am very, very pleased, along with Professor Zacharin, to introduce Mark Zaid. Mark is an attorney based in Washington, D.C. His practice and his firm specializes in, and I quote, innovatively handling simple and complex administrative and litigation matters relating to national security, international law, foreign sovereign and diplomatic immunity, defamation from the plaintiff's side, and the Freedom of Information and Privacy Acts. Among his many honors and awards, the National Law Journal once wrote, and for those of you who might remember the X-Files, if Agent Mulder ever needed a lawyer, Zaid would be his man. And if you don't, look it up, but not right now. He's also the executive director and founder of the James Madison Project, a Washington, D.C. based organization with the primary purpose of educating the public on issues relating to intelligence gathering and operations, secrecy policies, national security, and government wrongdoing. Mark is here today. He just gave a really interesting talk that I hope to have available as an audio recording to the faculty on some of the challenges that lawyers face in representing clients involved in intelligence matters, and I think he will continue that discussion with you over the next hour and a half or so. So I ask you to give a warm welcome to Mark Zaid.
Thank you, John, and Michelle as well. And if anyone, the other connection that I found I had with John in particular, if you've been to his office and you see all the Superman stuff that he's got in there, so I have a comic book business on the side as well. And actually I've turned that into a legal business as well, and I'm doing a book for the American Bar Association on comic books and the law as well. So you can actually make money off of comic books, even as a lawyer, so to speak. So the topics I'm going to talk about, I'm actually teaching a class on at Johns Hopkins next semester. So it is difficult to cover in the brief period of time that we're going to have. And I will say probably it might even make it more interesting for you guys so you can stay awake. If you have a question as we're going along, don't hesitate to bring it up. And I'm going to talk about, in particular, some of the classified leak prosecutions that are ongoing, the NSA surveillance programs, whether there's a war against whistleblowers, a war against journalists when it comes to national security. So for 20 years, I've been representing spies. That's the long and short of it. I represent individuals who work inside the CIA, the DIA, the NSA, you name the three-letter agency, that's what I do, State Department, military, all that fun stuff. And it raises, obviously, a lot of different interesting issues because sometimes the very employment relationship that these individuals have with their agency is classified, and one needs a security clearance to handle that case. And then how do you deal with that particular case? There are restrictions on, obviously, what I could say. You know, there are certain things I can't say standing here today because I would get prosecuted if the U.S. government found out that I said it. I have certain requirements on me for pre-publication review so that when I draft a brief that's going to be used in a CIA case, I have to give it to the CIA first for them to review it to make sure that it doesn't contain classified information, and then we get into a huge fight if they tell me that it does. We had a big case a couple of years ago, I think the decision was last year in the District of Columbia, on behalf of a woman named Sabrina D'Souza, who, that name probably doesn't mean anything to you, but if you read the newspapers in the last decade, she was one of the Americans prosecuted in Italy in an absentia for the extraordinary rendition of Abu Omar, who was an imam in Milan, Italy, and he was sent over to Egypt where he alleges he was tortured. And Sabrina was a State Department consular official in Milan, and she was prosecuted, and we tried to get the government to invoke diplomatic immunity, our government, to give her legal representation in Italy. She was sentenced to 9 years in prison, and The allegations have been for years that this was a CIA operation. Well, in suing the U.S. government, I had to litigate the issue of whether or not I could provide classified information lawfully to the judge in the case. The judge has a security clearance by virtue of actually their position, constitutionally. Same things with members of Congress, and which is a scary thought on many levels. And the government, the executive branch, did not want me to provide classified information to the U.S. District Court judge. And we litigated whether or not I had a right to do so. And the end result was the determination that I did, but that I didn't meet the burden that she wanted to impose on me to be able to explain to her why it was relevant. And the reason why I couldn't do that was because it was all classified. And I couldn't put it into a document that she would see. I can't write or create a classified document on my home computer, my work computer, because it's not a secure system. It's hooked up to Facebook. Everybody in the world, the Chinese are looking at my computer probably, every single day. So I have to go through all these procedures. Now, the last, 7 years, we've seen an increase in leak prosecutions. And a debate between where is the line between leaks of whistleblowers and espionage? Because the statute that they're being prosecuted under is called the Espionage Act of 1917. It is a World War I statute that has not been amended in 60 years since the Korean War. So you can imagine what the text of this statute says in relationship to what is happening now in the world with respect to the internet and documents and computers. And, it talks about lots of paper things. It was envisioning Russian Soviet spies stealing documents in a folder and smuggling them out on microfiche or microdots. And that, you would only be able to get the amount of documents that you could really grab, or your Minox cameras and taking photos, versus Bradley. I still refer to him as Bradley instead of Chelsea Manning. Bradley Manning, with no disrespect to the difference of that, but it's just easier. It's a strange situation. Bradley Manning downloading 750,000 documents onto a DVD that says Lady Gaga on it, or Snowden downloading onto thumb drives. We're not even sure how many documents that he did yet at this stage. And so the statute wasn't designed to be used against anyone other than real spies against our country. But we've seen in the last few years that it's being used more against those who have leaked classified information, whether they are whistleblowers, which we'll talk about, or they are, for whatever their reason might be, just someone who believes the documents need to go to some individuals, whether it's journalists, foreign power, but it's not espionage. And how does that interplay work, and why is that ongoing? Well, you'll see now in the media where a lot of people are saying there's this war against whistleblowers. And I've been representing whistleblowers in the national security community now almost 20 years. Individuals who've been accused of leaking information for almost as long as that time. And I don't think there's a war against whistleblowers. I think what there is an opportunity for the executive branch to gain access to evidence that it never had before. When I was representing folks back in the mid-90s who were accused of giving information classified to the Washington Times newspaper, we didn't even have email yet. So, you were talking on the phone. And okay, the U.S. government even back then, you could gain access to phone records that said this phone talked to this phone, but you don't know what the substance of the conversation was. Nowadays, everyone is talking on email, they're talking on Skype, they're talking on Facebook, Twitter. There's a written record that the U.S. government and other governments have the ability to seize. Now we've even been learning from Snowden's disclosures that the U.S. government has the capability of, I don't know how the heck they do this, of grabbing Skype conversations that we have had with folks overseas. that there's a mechanism that the information is being retained and is still grabbable. So for the first time now there's this evidence. Now some of the leak prosecutions in the last few years have been my cases. There's a case that's ongoing about Jeffrey Sterling. Jeff was a CIA case officer, African American, and I represented him starting in 2001. We sued the CIA saying racial discrimination, that he was being held to a higher level standard as an African American case officer than Caucasian, Asian, or other groups, that he was being required to recruit more spies at the UN than others were, and that he was being fired as a result of retaliation. And the US government invoked what's called the state secrets privilege and shut the entire case down because it was all classified, and they said we couldn't litigate that case. Well, Jeff has been accused and indicted of leaking classified information to the New York Times about, according to the New York Times book by Jim Risen called State of War, that the CIA had undergone a program to try and give inaccurate data to the Iranians for nuclear weapons, that they gave them plans and the plans were missing a key component, and that would have set back the Iranian nuclear weapons program however long until they figured out that it was a wrong plan. And supposedly the theory was, or the statement was by the person that they were going to use to carry this out, was that even they looked at it and they said, this is ridiculous, it doesn't work that way, no one's ever going to believe it. So I was Jeff's lawyer up through the criminal prosecution. I handled the internal investigation with the FBI, the lawsuits with the CIA, and then the US government did something unusual, and it subpoenaed me before the grand jury to appear, which was, obviously a quite strange situation as the lawyer for the defendant to be appearing before the grand jury. But I testified on unprivileged information, so there was nothing that I could necessarily hide, and I wasn't the primary lawyer because I'm not a criminal defense lawyer by trade. So he had another lawyer, so I got bounced off the case. That case is still ongoing because the government has subpoenaed Jim Risen, the reporter, to testify as to who his source was. That they can't prove that Jeff was the source, but Jim Risen, obviously, as the reporter, he knows. And so the issue is there a reporter's privilege? And there is no shield law that exists in the federal government for reporters. There are state shield laws, but not federal. And the Fourth Circuit, just within the last few weeks, reversed the district court judge that said there was at least a partial privilege, that the government should get the information elsewhere, and it's going to compel him to testify. And if the Supreme Court denies cert, Jim's going to have to decide whether he's going to go to jail or not, which is what he says he's going to do, rather than reveal his source. The other case is John Kiriakou, another CIA case officer who is now serving prison time for 2.5 years or so for having leaked classified information. He pled guilty to disclosing the identity of a covert case officer. I represented John when his case first started. He appeared on ABC News in 2007, and he discussed waterboarding. And he was the first CIA official to ever talk about waterboarding. We knew all about it. There had been leaks, there had been information and reports, but we had never heard about it from someone inside the CIA. That case didn't go anywhere. The government didn't prosecute him, so I stepped out of it. Someone else took over as a criminal context. And then when his criminal prosecution happened for a completely different set of facts, I represented one of the journalists that he leaked the information to and protected his identity, although it was reported in various newspapers as to who they thought he was, to make sure that the journalist's integrity remained intact. And he never revealed, the journalist never revealed he was the source, but the US government had all of the email traffic back and forth between Kiriakou and the journalist. So the government knew everything that John had said, again, going back to the evidence. Now, the two most recent cases that are high profile, that of Manning and Snowden, raise a lot of different issues, and that's just some of what I want to talk about. The first is, well, what's a whistleblower? The whistleblower generally has a very similar definition no matter where you check. They're going to be someone who is revealing information that is concerning illegality, waste, fraud, abuse, misconduct, typically of the government, whether it's federal, state, local, could be a private corporation, could be here at Touro Law School, right? You find out something in the admissions office, all right? I would say they're not letting, they have a quota for Jews, which wouldn't be here at Touro Law School, right? They have a quota for someone else, and that's against policy, and you blow the whistle on it, and you suffer retaliation. You know, we can all pretty much agree this is the generic definition of a whistleblower. Under federal law, when you're a whistleblower, that means you have to follow certain procedural steps. You have to abide by the law. You have to release the information, especially when it's classified, through certain channels. You go to the Inspector General's office. You go up your chain of command, whether it's military or civilian. You go to the congressional oversight committees. You go to members of Congress who have clearances. You go to a federal judge, whoever it might be. All these multiple steps, the Office of Special Counsel inside the U.S., which deals with whistleblowers, the Government Accountability Office, the GAO, that investigates for Congress concerns of waste, fraud, and abuse. All these steps in order to have whistleblower protection. Now, when I give lectures on whistleblowers specifically, I say, I don't pay attention to what the law says, to be perfectly honest, because in the national security context, it's virtually useless. There's no protection. In the CIA director can fire anyone they want. So can the DIA, the NSA, anyone they want. No due process, no good reason, so long as it's not illegal in the sense it's not discriminatory. It's not homosexual, it's not race-based, it's not gender-based, age-based. But, you know, you name it, they can come up with a pretextual reason to terminate them. And I can't do anything about it if that's the case. Now, 99% of the time they give them due process, and we have an internal process we can follow. But they don't have to. In Snowden's case and Manning's case, neither of them followed the procedures. And they just leaked the information in an unauthorized manner. You can never be a whistleblower by legal definition if you leak information to the media because you're giving that information to a third party without authorization. It is classified information. It is a crime. Now, are they whistleblowers? You know, generically speaking, the way we think of whistleblowers, many people obviously see them as whistleblowers. So let's take a poll here, not on the whistleblower notion. The question I would always get asked, especially when the cases first started, and I'd go on Bill O'Reilly or Anderson Cooper or whoever it would be, the text would be underneath me, hero or villain. So let's talk about Snowden. Is those who think Snowden is a hero, raise your hands. There's no right or wrong answer on any of this. All right. And who thinks he's a villain? Raise your hand. And who just doesn't know? All right, we got some. All right. This is a very, very gray area. I don't think it's black or white. Now, much of it's going to come down to where you might fall ideologically than legally. And this is one of the things that I've been trying to push within my own legal community as to what's the role of the lawyer and where should we be best serving the interests. What are the interests that we're serving? And how do we not cross the line into illegality or unethical behavior as a lawyer? So Snowden, let's look at Snowden. What Snowden did, and I always answer the question when I was asked hero or villain, I say neither. I say he's a criminal because he violated the law. Now you can discuss whether or not you think as a policy matter what he did was the right thing to do. But if we're talking about civil disobedience, if I can pronounce today, is talking about fighting against a policy or law that you believe to be immoral, corrupt, illegal, whatever it might be. And as we saw in the civil rights era, people took the consequences for it until that law, that policy was changed. Daniel Ellsberg, who leaked the Pentagon Papers back in 1971, he was prosecuted for unauthorized leaks of classified information. The case was thrown out because it turned out the Nixon administration overstepped its boundaries and illegally wiretapped his psychiatrist, broke into his office to grab unflattering information about Ellsberg, and so the case was thrown out for misconduct. but he probably would have been convicted. But Ellsberg, ironically, who will take a different position on this now than he did back then, he wrote the Pentagon Papers. He knew what was within the contents of the Pentagon Papers. And the Pentagon Papers, for those that don't remember, because probably none of you were born yet, it was a history of what happened in Vietnam, of our involvement in Vietnam. When he leaked it, actually in 1970, 1971, it was already a history of what we had done from the early 60s, late 50s until about 1964, 65. And it wasn't even about what the Nixon administration was doing. It was about what Eisenhower, Kennedy, and Johnson had done. And it revealed that the government had lied to us, the people, about what we were doing in Vietnam, why we were there, what was happening in Cambodia with the secret bomb. Well, secret bombing wasn't yet, but any of the extracurricular activities that was happening. And he first tried to bring it to members of Congress. He first went up his chain of command. Everything failed. So his last step was to take it to the New York Times, the Washington Post, and a number of other newspapers that nobody's ever heard of, that they were actually publishing it as well. Because the case was New York Times versus, or the U.S. versus. Now, when he did it, he stood on the court steps and said, I did it, I disclosed it, I'm willing to take the consequences. Versus what we're seeing now. Now, when I look at Snowden's case, when I look at Manning's case, I have to break them down. And I look at a lot of this in three different stages. When it comes to national security cases, what does the law say? What's the policy? What's the practice? And each of those may be different. The law says that possession of national defense information under the Espionage Act, essentially classified information, though it doesn't have to be, but it usually is now, is illegal. Does anybody own a copy of No Easy Day by Mark Owens, whose name is Matt Bissonnette? This is the Navy SEAL who helped kill bin Laden. Anybody have a copy of that? Has anybody ever looked at WikiLeaks? Anybody ever downloaded one of the WikiLeaks document? You're all criminals. By law. That's what the law says. I own a copy of No Easy Day. Anybody who does possesses classified information according to the U.S. government. By law, you're not authorized to have that information. You could be prosecuted. Well, the policy is no one's being prosecuted for having access WikiLeaks or owning a book that you can go buy at Barnes & Noble. The practice then is the same thing. All right, now it gets a little bit muddier when you have the individuals involved. So let's look at first the reporters. The law is that anyone at the New York Times who has classified information, they're in violation of the law. When they publish it in the New York Times, it's in violation of the law. When they disseminate it, when they ask or take it from a source. The policy is the U.S. government treads very carefully. Only in the last 100 years that, with some exceptions, let's say since World War II, only one journalist, one newspaper was prosecuted. Actually, the Chicago Tribune was indicted in World War II for having published a story that the U.S. government believed revealed information that we had broken Japan's codes. But as a policy, they withdrew the prosecution because they thought it would highlight the information too much. In the original days of the Espionage Act, it was written in such a way that you were not allowed to publish or disseminate any information that was, I don't remember the exact language, detrimental, essentially, to our allies in time of war. And in fact, someone was prosecuted, a filmmaker was prosecuted for doing a documentary on the Revolutionary War, which portrayed England in a bad light, because they were the enemy, but they were our ally in World War I, and so that was in violation of the Espionage Act. And that really kind of skirted and crossed the First Amendment. That provision was changed, so we don't see anything like that. But if we look at what's going on with the journalists, we had the AP had their phone records subpoenaed secretly. We had a Fox News reporter whose records were subpoenaed, and in the affidavit of the FBI, it said he was aiding and abetting the individual who had leaked. Those are all legally, factually correct. The policy always was we don't go after journalists unless we absolutely need to. We don't go after the journalists, we go after the surrounding information. The practice has been we don't prosecute journalists, we don't subpoena them, except in really unique circumstances. So the law is the same, the policy is shifting a little bit, the practice is changing. You know, in the Sterling case, they don't normally subpoena the defense lawyers to appear before the grand jury. The law allows it. The policy is we do it in extreme examples. The practice is this is when we can do it, and they did it in my case. So, for Snowden, let's look at what he released. He released information that caused an uproar about domestic surveillance. And I'm sure many of you have your own opinions, some of which may differ from those of us in the next generation, just a little bit behind you because we didn't have the internet the way you guys do. Our privacy interests are a little bit different, or what we expect privacy to be, than what you do. Our parents in the generation before, the baby boomers, they have a completely different notion of what privacy is. So all of that is changing and evolving. And that's changing also the attitude of how these national security laws are being put into place. And then obviously you add into the post 9/11 world of what do we need to do to make us safe argument. You know, in Britain, they have closed circuit televisions everywhere that the government's monitoring with facial recognition software. We don't have that yet. I mean, they exist, but you don't typically see them. But yet, you know, we have cameras everywhere because it's for security. Macy's has the camera for their building security. The ATM machine has the camera. So the Boston bombers get caught. How? Not by the government, but identified because all the surrounding buildings had film footage of everybody until they finally identified, well, who's that person with the backpack? And now they don't have the backpack. And then they put that out in the press, and then people call in, I know who that person is. It's so-and-so, Sarnoff. So Snowden releases about the domestic surveillance program. And you may think that the law doesn't allow it, or you may think the law allows it, it's a bad policy decision. You may think, I think the law allows it, and I think it's a good policy decision. I will say that at least I'll agree. I think he's a whistleblower on the standpoint of the domestic surveillance program. Quite frankly, it wasn't new what he released. We knew about these programs for the most part, but we never had the documents. So there were whistleblowers who came before him who were saying the NSA is illegally surveilling us inside the United States, but they had no proof. And no one paid much attention to them. We're a society that we need documents. So once the documents came out, it set off the debate. Is Section 215 of the Patriot Act constitutional? And you know what? We can have a great debate as to whether it is or not, and I'm sure we've got a multitude of opinions as to whether it is or not. So let's put him as a whistleblower in that. Well, he also released the budgetary information of the intelligence community. I have friends that have been trying to get that information for the last 2 decades. It's a wealth of information. It's fascinating if you're inside the community and this is what you report on. Did it reveal any waste, fraud, abuse, illegal conduct? All right, how about revealing information about the monitoring of German leadership, Brazilian leadership, French leadership, the UN? Is not that what the NSA is supposed to be doing? Isn't this what our intelligence agencies do? They monitor foreign governments. Now you could say, well, we shouldn't be monitoring Germany, that's our friend. Okay, that's a policy argument. You know what? There's a good policy argument to be made there. Germany's upset with us. French are upset with us. The Brazilians are upset with us. We don't monitor England, Canada, Australia, New Zealand. Those are the only countries we have agreements with that we don't spy on each other. Israel, one of our closest allies, They spy on us, we spy on them all the time. They spy on us probably more than we spy on them. These are not legal issues, though. They're policy issues. So when you look at Snowden having released this information, and newspapers having released it, where is the benefit to that? Now again, ideologically we can debate that. I don't think we should be doing anything like that in the world. You know what? I would love to live in the Federation of Planets and Starfleet, where everybody is all in love with each other and we're all peaceful. We don't need money anymore to buy things. That would be great. That's what, the 24th century? John, you probably know, right? That's the 24th century? We're not there yet. Not going to see it. We're in a world where the French government constantly commits economic espionage against the United States. When I'm defending individuals who have security clearances, who have a French background or French spouse, whatever, French relatives, what gets thrown in their face is nothing they did, no conduct of their own, but that, well, you have a relationship to France and France commits economic espionage against the United States. And so there's a risk that if we give you a security clearance, if the French find out that you have one, maybe they might use you to gather intelligence or threaten you. I mean, the French aren't going to threaten anybody most likely, but to use them from a standpoint of the relationship. The Brazilians, you know, bless their souls as they complain about us monitoring them, they have a domestic surveillance program. They monitor their own politicians, which they have seemingly forgotten to talk about when they've been accusing us of monitoring their communications with neighboring South American countries. But, you know, where is it in looking at Snowden as a so-called whistleblower? Where is that line? Can you be a whistleblower at the same time you're a criminal? Now understand, being a whistleblower gets you no legal protection, like I said. There is no exception in the criminal law that says, well, I'm a whistleblower, so I'm immune. Where it will come to play, like it no doubt did in Manning's case, is in sentencing. You know, what was the motivation of the individual? And the prosecutions that we've seen in the last few years have very much gone to intent. And there's the difference between the espionage statute and the leakers. What's the intent? Now, presumably with the leakers, the intent is to do good, to do something in the public interest. But do you want, again, there's no right or wrong answer, I have my opinion on this, do you want a 29-year-old, or in Manning's case at the time, 19, 20-year-old, making the decision as to what constitutes the best national security interests of the United States in leaking classified information, which I'll say they only have part of the picture about. You know, you always hear, if you've watched Homeland, or you watch The Americans, or the Bourne series, you always hear about compartmentalization, and the intelligence community is very much compartmentalized. So if I get a document here that says one thing, and I get a document here that says another, these documents might not be classified until I put them together. And within the two documents, it tells me an operation and the identity of a covert operative that links, say, a name with a company. So when Snowden and the others are looking at information, and Snowden, most of the information he grabbed from the NSA library, he had no personal knowledge of. He wasn't dealing with it in his job. He just went into the library, and in the position that he held, he was able to download it and then decide to just release it. He wouldn't know, and of course he's not a lawyer, he's not going to have some of the capabilities to understand, well, is this a constitutional program? He made a policy decision that he thought domestic surveillance was improper, illegal, whatever word you want to put into place. Now, if you agree with the policy, you're going to think he acted illegally. If you disagree with the policy, you're going to think, like I said, he's a hero. But regardless of which one you think, do you want someone making that decision? What if he's wrong? And we find out a year, 2 years from now, 5 years from now, that something he released ends up killing someone. Where's the line? How long in time before someone maybe got killed or maybe some terrorist attack wasn't prevented? Now, there's lots of civil liberties issues that we would need to debate to understand, do we think, again, this is the policy that we want? And Benjamin Franklin has a quote that I don't remember the text of something saying, you know, we're not going to give up our civil liberties to gain national security. To give it up or something like that would be to sacrifice what we fought for in the first place. So there is that line that we need to try and obviously to determine. But colleagues of mine recently gave Snowden an award, praising him as this model of a whistleblower. Now, I look at that as actually sending a message to other national security whistleblowers that this is what you should do. And if this is what you should do, I think that's a bad example. Because what I know will happen is it forces the U.S. government to take a very aggressive position against Snowden, who's already been charged with 3 offenses, but in anyone else who might follow him, because they need to set an example. And it's like rattling the cage of a lion with a tin cup. You know, you can stand back and you can look at the lion's not going to do anything. And you start running back and forth and rattling his cage, pissing him off, he's going to react. And if he can grab you, he will. So one of the other things that I do routinely is represent folks who write books from within the CIA and the different agencies. So some of my clients right now are writing a book about what happened in Benghazi on September 12th, 2012. September 11th, 2012. 11/12, actually, when our ambassador was killed. And I represent some of the members of the elite security team, is what I'm authorized to tell you they were, in the annex, non-State Department people. Now, that book has to go through pre-publication review, so I'll challenge the policy as we go through the process to make sure that it meets the classification needs of the U.S. government. But we're going through the process. I had a client the other day, it was an agency client, and he was told you can't publish the book at all because there's nothing that's going to be unclassified, or at least there'd be so much of it that wouldn't be readable. So these are the issues that are coming out. Now, one person wrote a book a few years ago, former CIA covert, submitted his book for review. They told him, no, you can't publish it. He said, screw you, I'm publishing it anyway. And he did. Donated the money to charity, apparently. It's actually a client of mine, publishing house, that published it, but I didn't have anything to do with the book. And I remember being asked by the media, what do I think about it? And I said, well, I'm really unhappy about this because now this is going to make my life and every client of mine's life difficult because this is taking the tin can across the rails of the cage of the CIA. And first time in 30 years, the CIA sued this person civilly for failing to uphold their contractual obligation to submit the book for pre-pub review. Didn't prosecute them, sued them civilly as a contract. It says, for in perpetuity, I agree to always submit any writings, speeches, books, manuscripts, whatever, to the agency, to the government for review. He didn't do that. Easy case, civil verdict, captures all the money, trust in perpetuity, royalties, whatever it might be. You lose everything. Now, maybe it was worth it to him to do that. I don't know. I think they're still deciding the financial penalty. Then that was the first time in 30 years they did that. Then in less than 2 years later, the CIA sued someone else who did it. In fact, I had not even heard of this person's book before. But something about it pissed off the agency and they went after him. So the message now is when you are, just like in life, when you're in someone's face, you're going to create a reaction. And now any national security whistleblower, and a legitimate one, who comes forward is going to face a much harder task of being a whistleblower than before because of, in my opinion, Ed Snowden. You had a question? Yeah. Yeah, excellent question. So the question is, what if the very people with whom you would normally bring the information to as a whistleblower are part of the problem? And that happens very, very often. And in Snowden's case, as much as I think every whistleblower in the national security environment has an obligation, legally for sure, morally, I believe too, that when you are debating if you're going to leak classified information, you need to go through the steps first, even if they're futile. And in Snowden's case, I agree. I think a lot of the steps would have been futile. The Inspector General, certainly his chain of command wouldn't have done anything. The Inspector General's offices wouldn't have done anything. The Ombudsman wouldn't have done anything. The Intelligence Oversight Committees wouldn't have done anything. Now, understand, let's look at, again, what Snowden was releasing. Let's just talk about the domestic surveillance program. This was a program that was authorized or created by the President of the United States, first by Bush, then by Obama. It was funded with knowledge by the Congress, at least by the oversight committees, had knowledge, and funded by the entire Congress. So now we've got the executive branch, we've got the legislative branch, and it was overseen, although you can debate how much it was, overseen and approved by the judiciary, at least by the FISA court, Foreign Intelligence Surveillance Act court. So 3 branches of government, we only have 3 branches of government, and they've all signed off on the constitutionality and applicability of the program. Now, it may end up being decided that it's unconstitutional. Maybe the Supreme Court will weigh in on it. We'll see. But other than going to maybe Rand Paul or Senator Wyden, it probably wouldn't have gotten much progress or any assistance going to really anywhere. Now, he could have, and I would have had him do, file a federal lawsuit that would have raised the profile of the information that he had. I have a case right now against the CIA for a John Doe. It's a CIA covert paramilitary officer who's accused of war crimes. And there's nothing in there that says what the war crimes are. In fact, we were never told. There's an active IG investigation inside the CIA. And we are suing to get them to render a decision. What are you going to do about it? Close the case. Either close it or do something, because you're making this guy's life miserable. You ruined his career. And the Justice Department denied or declined prosecution. So before I filed the lawsuit, no one knew that there had been an IG investigation for war crimes committed by Americans in a country that I haven't identified. No one knew there had been a criminal investigation of war crimes committed by Americans in a country I haven't identified. I put that on the record. I haven't identified it for my friends in the agency who are listening. When I filed the lawsuit, got a lot of press because this was all new information. Now, it didn't spark the controversy the way Snowden's disclosure did because I don't give him documents. But it got a lot of interesting press about what's going on with this case. And hopefully it gave him, my client, a little bit of protection. It was just another step in the progress. Now, I think it was the AIPAC, American-Israeli Public Affairs Committee prosecution of Rosen and Weisman, Rosen and Weisman. I worked on that case through a witness. This was in the Eastern District of Virginia. They were accused of receiving classified information from a DIA official and then giving it over to a reporter and Israeli government officials. Now, the 2 men from AIPAC did not have security clearances. They had no contractual obligation to protect the information. They had no legal obligation to protect the information. They really were doing what everybody does in Washington, which is leak information, receive it, pass it on. And it was the first time someone was prosecuted for that type of offense. And the prosecution collapsed, primarily because of one of my clients who was saying the information wasn't classified, which would obviously be a prerequisite for the prosecution, but also because they didn't have the intent, the judge held, they didn't have the intent under the Espionage Act to harm the interests of the United States or know that it would go to the benefit of our enemy, the advantage of our enemy, I think is how the language is. The judge in that case or one of the other, I think it was that case, it was one of the espionage cases, went on the record and said that there might be times where, at least as a matter of principle, that you will feel, you whoever, would feel strongly enough to leak classified information in the hope that you're going to affect a positive change inside our country. But if you do that, there are consequences that flow therefrom. And you need to step up to the plate and accept those consequences. And maybe you'll be proven right, and that'll have an impact in the prosecution, or you will have to serve whatever period of time as a matter of principle, as a matter of civil disobedience. I don't know why I'm having trouble with that word today. That was pretty heavy stuff for a federal district judge to make a comment like that, basically saying, you know what, and our ethical rules talk about it. If we believe that a legal policy is incorrect, or a decision, since we are on the basis of precedent, and we believe that decision to be wrong, we can argue the contrary position. We might even be able to do something illegal if we argue that position, but there could be consequences while we're doing it. If we're proven right, those consequences don't flow. I handled a case involving the anthrax vaccine, if anyone was in the military in the last 15 years. Starting in 1998, there was a mandatory requirement for everyone in the military to receive the anthrax vaccination. 6 shots over 18 months, crappy vaccine. Most painful shot that everyone got, and there were a lot of very serious health consequences. But it was a licensed vaccine since 1970. So when you were told, go line up, get a vaccine, it was a lawful order. But because people were concerned that they were going to receive Gulf War syndrome or some serious health effects, birth defects, a lot of people refused to take the vaccine, and they refused the order. And I defended them in their court-martials. And the argument in court, in the military court-martial, was it's an unlawful order from the Secretary of Defense because it's an experimental program. Well, in the military system, that didn't fly. I wasn't going to convince a colonel who was a judge to decide that the Secretary of Defense had implemented an illegal policy. That would be really major chutzpah on their part. So my clients went to jail for 30-day periods of time, and then they got discharged. So we turned around and we sued the federal government, the Defense Department, the FDA, in civil court in D.C., and we alleged the program was illegal. And we beat them in federal court. And the program was determined in 2003 and 2004 to be illegal. It was an unlawful order. So really, everybody who had objected and refused acted lawfully by refusing the order. And that's, the same here. Go take that hill. I refuse to do that. Well, you're going to be prosecuted because even though you're going to die when you take that hill, that's a military mission. But go bomb that schoolyard. Go bomb that church. No, bomb the civilians. I'm going to refuse to do it. That's an unlawful order protected by the Geneva Conventions. You can't do that. So, but obviously the people who were the protesters, civil disobedience, they went to jail. Now, they felt vindicated when we challenged and defeated the policy, but they suffered the consequences. So, that's, I don't put myself in that position, so I can't put myself in Snowden's position as to, whether he did the right thing or not. And frankly, time will tell as to whether he did the right thing or not. I throw out to those who believe the policy is an illegal one. Well, what happens if the Supreme Court does hear the case and the Supreme Court says it's constitutional, that everything the NSA has been doing, there were instances where there was misconduct. NSA stepped in and fixed it. There were instances where they didn't give enough information to the district judge who was on the FISA court. They stepped in and they fixed it. So the program, the way they're doing it, is constitutional. So what are we going to do now as a society? What's left to us? There's revolution, if that's what you want to do. You certainly can protest. You can vote your elected officials in and out of office. But, we're at a crossroads, and so much of what we're doing now with civil liberties and national security, and you as, soon-to-be new lawyers are going to be dealing with all of these cases. colleagues, friends of mine who are AP reporters just came out with a book about the New York Police Department and all the surveillance the New York Police Department was doing, particularly in the Muslim community, in mosques. You know, everybody always thinks that everything that's going on is at the federal level. Actually, much of what's going on, more of what's going on, is at the state and local level. Because if you think about who do you interact with, you know, on an everyday, you don't necessarily interact with the federal government every single day. You interact with state and local every single day. We're drawing near. We're going to take a break?
No, actually, we'll go through till 3:15. It seemed like a good place, perhaps, to maybe move the discussion a little bit and bring in some more participation. First of all, thank you for this. But these are both cybercrime classes. And while certainly what you're talking about is criminal law in nature, but much of the reading, much of the discussion, and much of the practice that our students are going to be involved in is going to be much more in the realm of traditional crimes. And so I was wondering if you have any thoughts about how some of the issues you're discussing may impact on more traditional law enforcement and criminal cases. I know that in my section, for example, we've been looking at the Fourth Amendment issues and questions of illegal searches versus legal searches. And we came up with the sort of challenge of where does the standard lie if the information that led the police came from a FISA court warrant, right? Where it wasn't that the police got a warrant, but the information that led them to this investigation, gave them probable cause, came from a totally confidential, non-challengeable, non-investigatable something. And how does that play out in terms of exclusionary rule and everything else? So I was wondering if you either know of situations or sort of seen where these national security issues are filtering down or impacting on more domestic criminal law issues.
Right, so we learned just the other day, right, that I forget the individual's name. I want to say it was out in the West Coast. There's the first case that's now coming up in in a terrorist case where there is evidence that was derived from the FISA court, from NSA surveillance, that is now going to be litigated as to the constitutionality. You know, one of the problems that's been happening with all of the domestic surveillance programs and with respect to any of the prosecutions is that there's been no successful challenges because it's all been thrown out on standing grounds. Because how do you prove you were being domestically surveilled? Or how do you prove that there was evidence that was derived against you? Because the government's not relying on that evidence, even though there might be something that led to the fruit of the vine and such like that, but that wasn't what they were relying on. That's obviously becoming a much bigger problem. Now, in the leak prosecutions, somewhat ironically, as I keep having to remind everybody, as far as I'm aware, there's been no evidence used against any of the individuals who've been prosecuted in the last decade in the leak cases that came about through any type of certainly illegal wiretapping or even legal wiretapping. I think some of them have been subpoenas and phone records, electronic records, emails. In the Thomas Drake case, which was an NSA case, and he was one of the people who went to Russia to give Snowden the award, and he's unfortunately one of the people who's being, he's a true whistleblower, and I think he did the right thing is what he did, and he actually revealed waste, fraud, and abuse of programs the NSA was conducting with respect to the financial aspects of the program, how much it was costing, and he was prosecuted for it. He used hushmail to communicate with a reporter for the Baltimore Sun. And the thought was that the US government could not break the encryption of hushmail. Now, some of the Snowden documents indicate that might not actually be true. But what no one really realized, so if any of you are using encrypted email communications for whatever reason, you have to be wary of where the company is that is providing you the service. Because if they're in the United States, the encryption is irrelevant, because the US government just goes with a national security letter or a subpoena and says, I want to see the email traffic. They don't have to worry about the encryption. The service provider turns over all of the hard copies of your communications, and they go around the encryption technology. So if you want to use encrypted discussions, you need to find some place in Prague that's providing the services, or Vanuatu,
or encrypt it yourself, and then so that they can't read it.
Yeah, however, beyond my level of technology. But no one, the government has not relied on in any of these cases any type of situation like that. Now, we're seeing obviously with the Snowden documents now, the one document that first came out was a FISA court order, just the order, that renewed Verizon providing the metadata over to the US government. And it raised this big stink. Actually, it had been an ongoing, revived practice for about 7 years, I think, since 2005. And so there wasn't even anything unique about it. It was a no-brainer as far as the court was concerned with respect to the metadata that they were obtaining. And it was being done legally. So is said, at least by the order. And why were they capturing the information? And this is where some of this comes into your privacy and the aspect of cyber technology and warrants. Most of this information was from a private source anyway. If you lose your phone bill, you can just call up your phone company and say, could you give me the phone? Now you can probably go online for most of it. Can I have my phone bill for the last 6 months, whatever time period that they have that they've kept it. Now they've made a decision that they only keep the information for X period of time because they'd have too much information. And that's what the US government is looking at. So the US government wants all your cell phone records. They're not looking at your records. They want it so that if you get caught or you come up in an investigation, that they can then take your cell phone number, like in the Boston bombing case, put it into their database and come up with your records, and then they see who have you been talking to. I mean, at least superficially, I would think everyone would agree that makes a lot of sense. Wouldn't you want to know who the Boston bombers were talking to in the days, weeks, months, maybe 3 years before, to see how long this plot, because many of these plots, not their case, but many of these plots have been going on for a number of years. And that's how good some of the sleeper cells are for the terrorist organizations. So this is information that private companies have on you that you willingly give to them, whether it's your Facebook accounts, your Gmail accounts, anything with Google, of course, Amazon. They're collecting far more data about us than the US government is. And actually, they're using the data, which is why you keep getting all the annoying ads from them on the side of the page that says, oh, this is what you should buy. And you're like, how the hell would you know that I like that? Well, because that's the computer programs doing it in their matrices. So it's really the US government is behind the 8 ball, getting access to the information that the companies have. In that sense, most of the time, they don't need the FISA court involved. They're just issuing their regular warrants like they normally do. Now, they might issue a national security letter because they don't want anyone to know that it was done, because they don't want to tip off, much in the same way with any criminal, you don't want to tip off. But because it's national security, they've increased the level of importance because of what the damage potentially could be.
Based on your knowledge of how these agencies work, if, for example, in the course of reviewing their electronic surveillance, an agency analyst discovered that there was an American who was trafficking in child pornography. And at least half of the cases in the case books that we use are child porn cases, because those are the ones where you have the challenge searches. Those are the ones that end up in the reported opinions.
Right.
And often you get people who report suspected child pornography people in work or whatever. So do you think, or maybe have you heard, of an NSA analyst NSA data source, discovering child porn, passing it along to local law enforcement, and what kinds of constitutional issues might that raise in your view?
Actually, I have those cases all the time. So the NSA is very aggressive on child porn cases. The way it typically comes up, though, is in a polygraph examination of a contractor or an applicant or an employee. And one of the questions, if it's a lifestyle poly, there's counterintelligence polygraphs. They just ask you about, are you providing disclosure and classified information? Are you in touch with foreign intelligence services? Very narrow. Lifestyle starts to get into drug use, prior arrests. It's a fishing expedition. And one of the questions they'll ask you is, have you ever committed a serious crime? And they'll have a pre-test exam, you have the test, then you have a post-test discussion. And most of this comes up in the pre-test. Have you ever committed a serious crime? The Secret Service used to give you a piece of paper that listed all sorts of serious crimes. One of it was sex with animals. And I had that a few times. Not me personally, but cases. Where the person admitted to having sex with an animal. And that was the basis. This is all security clearance decisions, which are all administrative. So you wouldn't see them in any of the published case decisions. You can't sue on security clearance cases in federal court. Although there are some Defense Department cases that you can look at that deal with child porn, but it never deals with the constitutionality. So NSA talking about it, and they'll talk about child porn issues. So they'll talk about pornography issues, and the question, somehow it'll come up on pornography. It's usually guys. And the conversation, anyone who's a guy here who's looked at pornography, lawful adult pornography, will have to, I think, if you're going to be honest, say, I don't know if I saw child pornography because I don't have a clue of how old she was. She says in the video she turned 18 yesterday. Maybe she did. Maybe she was still 17. Maybe she had a fake ID. Maybe she was 23. Oh my gosh, I just blanked on her name. Famous porn star in the 80s who was in when Zach and Mira made a porno, the movie. Oh, come on, guys. Someone's got to know the porn star's name.
Apparently, they're not polygons.
Oh, my God. Wow. Her name will come to me. Anyway, she was the top porn star in the 1980s, and she made 107 films, and she lied about her age. She had fake ID. And she was actually in Penthouse, the issue with Vanessa Williams, which probably means nothing to you guys. It was a big deal when Vanessa Williams, she was Miss America, and nude photos of her surfaced, and Penthouse got them. And so she's in this issue too. So it's all child pornography. Now, all of her videos are all child pornography because she's under the age of 18. Now, child pornography, what people don't usually know, so just you yell out, what would be an example of child pornography? You can yell it out or raise your hand. Just give me an example. Okay, absolutely, yes. Not necessarily, and this is where the difference is. Now, that's a big problem
for the purposes,
nowadays.
For the benefit of the
Yeah, no, I'll say, so the child pornography has a very specific definition. It's someone under the age of 18, and they have to be engaged in sexual activity or lascivious conduct, something that is simulating, say, masturbation or oral sex, something like that. But just a 15-year-old posing nude is not child pornography. And most people don't realize that. So in these polygraph exams, when they're being interviewed, they start saying, well, look, I don't know, I saw these images, maybe it looked too young. I mean, if it's prepubescent, it's pretty obvious. But, anyone who watches the Disney Channel now knows, these girls who are like 15, 16 years old, and they look like they're 25, and they're dressed up, and you don't know. And there's a whole body of science on determining age, and people come into criminal cases to testify on how old the person is in the video. And for example, Asians are incredibly difficult to determine age for. And so they'll say, well, I think I saw child porn, and I think I possessed child porn. And NSA will notify, there's a task force, a joint task force between the FBI and local law enforcement in Maryland, where NSA is, and NSA will notify the task force, and some period of time later, that person will probably be visited by a detective at 6 o'clock in the morning, asking, can I come into your house and look at your computer? Now, no warrant, so it's voluntary. I've never seen a case where they have used FISA, for one, two, even had to use a warrant. They just do a peripheral investigation. Most of the time, because there's never any child porn involved with these cases. It's just some guy saying, oh, I don't know if I saw it or not. Maybe I did, yeah, I think, and the polygrapher will walk them back. So could she have been 17? Yeah, sure. 16? Yeah, I suppose. 15? 14? No, I don't think she could be 14. That's the typical conversation. I get these dozens of times a year in security clearance cases. And so most of the time, when we hear about all these constitutional cases, they're the fringe of the situation. It's not what is normally going on. The law enforcement authorities have pretty much every tool in place that they already need, that they've had for decades, and there's no difference in that sense from the difference when I was talking about the Espionage Act being used for real spies versus what it's being used for now and how it's been impacted by digital media. Not as much so with respect to how child pornography now is caught. It's easier for law enforcement. It's more prolific for the child pornographers because of the internet. But the tools that they're using for the most part are the same. Now, the FISA court, things like that, I mean, I have had cases where they'll tell us they had FISA information. And it was in the one case that I remember involved Cuban espionage. And a U.S. government official, a lawyer in fact, was a Cuban heritage and had met a Cuban official at a party and had exchanged a resume and cultural contact. And it turned out that Cuban official, at least by our synopsis of what the FISA information was, because they didn't tell us, was being monitored, was clearly being monitored because they grabbed her communications with the Cuban officer. Mm-hmm. And, he was perceived to be, or was, a Cuban intelligence officer. So there was FISA court information. And they used that to deny her security clearance. Now, there's no constitutional argument I can make in those cases because having a clearance is a privilege, not a right. So there's no constitutional protection with that. We had a big case that went to the Supreme Court. I guess you probably would have discussed it with the tracking device on the drug dealer's car in Washington, D.C. That's now back at the lower courts because they had a warrant for X period of time and then they just let it lapse and they said, well, we're putting it on the license plate. It's a public license plate, so why can't we do that? Where does that violate necessarily the Fourth Amendment or any other amendments? Maybe Sixth, I suppose, perhaps. I don't know. One of the other issues that comes up, maybe, I don't know if you guys talk about with respect to the monitoring of the lawyers and their communications with clients, and with, for example, like Gitmo cases, or some of the cases here in the United States. I had a great panel at the International Law Weekend Association, which is in New York City in October every year. Back in the late 90s, we had Ron Kuby, who you might know of. He defended a lot of terrorists. I had two prosecutors from the first World Trade Center bombing in '93. And then I had Lynn Stewart. And I did Crossfire. I was the host. And that was when Crossfire now I think sucks. But it was good back in the 90s on CNN. And Lynn Stewart is now serving time in prison. She represented the blind sheikh. And she's in prison as the lawyer for having relayed messages that the sheikh had given her to his followers, which were overheard and during monitoring of their attorney-client privilege communications, which was decided not to exist because of national security reasons. Now, she knew she was being, I think she knew she was being monitored. But these are, and this was in the very beginning, early days, obviously. I don't even think we had, I'm not even sure we had email yet, really, at least that everybody had. But those are the types of cases that are still coming up. I have colleagues and friends of mine who are Gitmo defense counsel and prosecutors, and this is all the issues that they're hearing and having to deal with in Gitmo. These are all the issues with respect to the reporters. Now we can talk about the role of the reporter and where's their constitutional right. Do you look at it from a First Amendment standpoint? You're looking at it just on a Fourth Amendment standpoint. So you guys interact. First, does the First Amendment give reporters the right to receive classified information and report on it? Yes or no? Yes, raise your hands if you think First Amendment gives a shield of immunity to report on classified information. Does anybody believe that?
For the benefit of the camera, we have no hands up.
Okay.
We have half a hand up.
Half a hand. Right? So, the First Amendment doesn't give any protection with respect to anything that the reporters are doing. And like I talked about earlier, there's the policy, there's the practice, but those are different from what the law is. So, but this is what they're talking about with whether or not we're going to have a federal shield law. And every time they keep proposing it, though, they keep putting an exception for national security information. So, how is that going to be put into play? We're looking at whether or not there's supposedly a covert grand jury for Julian Assange and WikiLeaks. And you get a debate, well, is he a journalist? Is he not a journalist? Is he a reporter? Is he not a reporter? A publisher or not a publisher? Not sure if it really matters anyway, because he's not authorized to have the classified information and he's disseminating it. And there's nothing in the law that distinguishes between American and non-American citizen. Obviously, there are jurisdictional issues, physical custody issues. That's why he's hanging out in the Ecuadorian embassy in London for the last year plus for that, although he's wanted on charges in Sweden for having nothing to do with WikiLeaks for alleged rape charges. What else can we talk about?
Well, I know you had said in your faculty talk, talking about the idea of attorneys being monitored, that it's not always electronic monitoring. You spoke of a situation where you had gone with a client to, I guess it was, to a congressional meeting, and you had both signed the book, one after the other. And that could have, and then the question was, who's your client? Who are you representing? And while you didn't disclose it at that point, the fact was, and you were aware, that if they had simply looked at the sign-in book and said, okay, you sign in, that same time, here's this person of interest. It answered their question. So there's information out there that is not so difficult. You don't need surveillance technologies.
No, it's amazing everything that we do now as far as being tracked. Now, one of the other cases that's going on the leak prosecutions was this Fox News reporter that I mentioned. Well, how was it that they singled out the individual at the State Department who was leaking the information? No secret warrants that I can remember. I think there were warrants, there were subpoenas, but they were able to prove that the reporter, this would be at least from a circumstantial standpoint, the reporter met with this individual. And how do they know that? Because he went to the State Department headquarters and he signed in, showed his ID. Who was his escort? This was the escort. That doesn't necessarily mean that there was the exchange of classified information, because they don't know, obviously, what was discussed. But that, from a circumstantial standpoint of tying into, when you have these leak cases, what goes on is the agency whose equities were at stake reports it to the Justice Department, and then the Justice Department tasks the agency identify how wide a magnitude is the audience of people who knew this information. So obviously, the higher the classification level, the fewer people who knew the classified information. So you start singling it down. Where was this person on these days? Who did this person? Grabbing their phone, everybody's phone records, Certainly in the government's entitled to all the phone records. Government's entitled to all the emails on the government system. It's a lesser question, and I don't know the answer to this, whether or not, because my clients, people do it all the time, you access your personal email system, but you're on your government computer.
Well, there are some cases, fairly recent cases in New Jersey, not in the government context.
It would be the same private employment, I would imagine.
And ultimately, the New Jersey Supreme Court, and that was the Stengart versus Loving Care case. Right now, the New Jersey Supreme Court has, to a certain extent, upheld the privacy rights of an employee checking personal email through a work computer, very specific context, because it was a lawsuit against the former employer. The employer had the emails, even though it was done through Yahoo Mail, because there had been a temporary file that was left on the computer. So they had the information. They wanted to know if it was admissible, they could use it. They were permitted to use it. And ultimately, the New Jersey Supreme Court said no. But that is, certainly that could very easily be differentiated by the facts of the case. I don't know whether it was based on federal constitutional law, New Jersey's constitutional law, a New Jersey state privacy right, but those are our key questions. I did want to sort of ask one more, and then we'll see what questions we have from the students. And again, trying to look to taking the lessons and the things that you're seeing on the national security front and bringing them down. I wonder whether you think that the increased scrutiny over those practices in the wake of Snowden and Merkel and everything else will have any impact on the comfort level, the likelihood of local law enforcement using similar kinds of methodologies. There was a case, not a reported case, but there was a situation that was in the press a number of months ago here on Long Island after the Boston bombing that I guess she was a blogger, said that she was visited by, I think it was ultimately Suffolk County Police, on some suspicions of terrorism because her husband's at work had searched for pressure cookers and backpacks because they were cooking something and they were camping. And in the wake of Boston bombing, those two terms together caught someone's attention, and it ultimately got passed along to local law enforcement that came and knocked on her door. Not dissimilar in terms of what's happening, at the national security level, but very local. And I wonder whether you think that the criticism and the scrutiny on the national scene is going to impact on the tools that local law enforcement want to use and decide to use.
It's absolutely impacting. Now, that case was really interesting because I remember writing about it. And part of it was that it got, at least as I understand the true facts to be, it got somewhat distorted in how it was reported. Because it made it look like Suffolk County Police Department was monitoring people's emails and coming, or at least the search algorithms, and finding this interplay of backpacks and pressure cookers, when it was, I want to say the guy worked at like Grumman or Lilco or something like that, and the employer saw the searches on the work computer, which they are authorized to go into, and then out of a heightened sense of concern, reported it to Suffolk County Police, and then Suffolk County Police shows up at the person's house. So once the facts started to come out, at least to me, I'm standing there going, well, isn't that what we wanted things to happen that way? I mean, maybe the cops might have acted too aggressive, which often happens, unfortunately. Maybe prosecutors did, whatever. But the process that it went through, isn't that what we want? And again, now you can start debating, and I've had to deal with insider threat issues. When is it that you report your friends? Are we getting back to the 1950s in the days of McCarthyism in the House Un-American Committee in reporting anybody who we suspect to be a member of the Communist Party? But in this case, it would obviously be that you're a member of Al-Qaeda or sympathizer with some terrorist group or supremacist group or something like that. When it goes back to what I was saying about local law enforcement and state, or local and state governments, I think most people don't realize how integrated they now are with the federal system. They are being trained on a daily basis by federal law enforcement and federal intelligence agencies. Most of the major law enforcement communities have intelligence officers that are in them, their own people, and they are getting trained by the federal government. And again, this was the book that my AP Associated Press friends just wrote about the New York City Police Department doing surveillance of mosques in and around New York City. And they had a CIA officer assigned to the police department of New York City, which when that came out publicly, the CIA decided or somebody decided that was a bad thing, perception-wise, and pulled the person back. But, there is a lot more going on at the local and state level that is going to come into play with everything you're covering than perhaps at the federal level, or at least it is done in conjunction with. And that will raise different issues because the degree you might be studying, there are some states' constitutions that are actually much stronger, much more protective than the federal Constitution. Commonwealth of Virginia's Constitution is actually much stronger from, I want to say, a First Amendment standpoint, I think, or First, Fourth, Sixth Amendment.
I know in our collective class readings, we just had a case where a state constitution took a different view of, I guess it was the metadata surrounding email under the Pen Register statute than did a federal court in similar circumstances. And it was based on state constitutional jurisprudence.
Yeah, and the problem, much of what you guys are directly covering, and obviously I have to skirt around the issue, because all of that comes up in the criminal context. It doesn't come up in the personnel, employment, contractor context, because they don't have any constitutional rights other than the basic protections that anybody would have from discrimination. Yes, you can be, you can't have guilt by association with your people that you're hanging out with, et cetera. But in the national security world, the law is so skewed towards the U.S. government that unless it's so blatantly illegal, there's not much that we can do. So again, when I had this case about the Cuban espionage and Cuban intelligence officer, it was amazing that they even told us there was a FISA information that they were relying on. But there was no basis that we can do to challenge that FISA order, unlike if it was in a criminal case where there's a right for confrontation and a right to obviously know the evidence against. Now, in these criminal cases, do you cover Classified Information Procedures Act at all?
We haven't yet.
So you'll learn maybe about what's called CIPA, C-I-P-A. It's a statute from 1980. It was designed to prevent what's called gray mail, which is sort of a softer form of blackmail. It was in these classified cases that if I threaten for you to prosecute me, if you're going to prosecute me, I'm going to release through the criminal process classified information. And there's a process then that was created statutorily that says in those cases, the judge will make a determination if it's relevant or not. If it's relevant to your prosecution, your defense, you're entitled to it under law. But can we do a substitution? Can we substitute summaries, unclassified summaries? This could be witnesses, could be documents, testimony. And the government then is forced into a decision that if they believe it is too important, and this was how Ollie North was able to on some extent, have his prosecution dropped from Iran-Contra. If the information is just too sensitive to the U.S. government, the government has to make the choice, if it's determined to be relevant by the judge and available to the defense to be put on during the trial, to drop the charges. So it's gray mail. You've successfully gray mailed them. Now, that could come into play with FISA information as well. This is all things that are obviously developing, as you guys are sitting here in school. And it's certainly not going to be decided by the time you graduate from school. It'll be going on for quite some time, and as technology advances, it's going to get even worse. And like I talked about in the very beginning about the differences in the privacy interests of us as from a generational standpoint, the less you're concerned about your privacy, the more you put out there about yourself without any concern, the less the law is going to be concerned especially from a policy standpoint, because it's going to be acceptable to you. So you need to make that decision. Actually, when I lecture to students of any age about getting security clearances, say you want to work for the federal government, and you're going to have to fill out what's called an SF-86, 127 pages. And some of the agencies now are asking, I just had my background investigation for the FBI, do you have social media accounts? Okay, yeah, so I got Facebook, Twitter, LinkedIn, maybe you have, I don't know if anyone uses MySpace anymore, or Instagram, Pinterest, all these things. All right, so what right, and this could be private, and this has come up, I think, at times in the private community too, what right does the prospective employer or the government have to have access to that information? Well, if it's public, everybody can see it, so everybody can look at it. And it's amazing when I see people get up in arms about the federal government looked at somebody's Facebook page, but it was the public Facebook page. So what are you putting up there on your Facebook page? Think about it. I was in a fraternity. I had some really cool parties back in the 80s. Is anyone a Sig Ep, Sigma Phi Epsilon, anybody? Or anyone go to Cornell?
Anyone remember being a Sig Ep?
Right? We had Red Death parties, which is...
You sure you want this on the recording, Mark?
I've talked about it a bunch of times at my university. We had some really massive parties. And thankfully, there's no photographs that I know of what went on at some of these parties. Nowadays, you guys take photographs of all these parties and you put it all over Facebook and you share it with your friends and you tag them. And of course, if you tag them and if I'm friends with them, now I see it and I can just right-click and save it, and you're all drunk and having a great amount of time, and boy, it looks like it was a party I wish I was at, unless you were my attorney general in Maryland who's up for office for the governorship, and he was seen at a party of underage drinking, and that's been a problem. Yeah, he found himself on Meet the Press this past weekend. That wasn't a good thing. But, do you really want that out there on Facebook? For now, Facebook owns it and can do anything they want. And is there going to be a time when the U.S. government, or, hey, you go to work at Luco, go and pull it, or get access to it? Yeah.
Are asking for passwords, not just accounts.
Right, and that's the next step. The federal government has drawn the line so far. They are not asking for passwords. They are checking whatever they can find, and they are turning down people for employment because of the photos that they've seen on there.
I mean, there's been reporting that the Florida bar years ago said that a candidate for admission who said he or she had beaten substance abuse but had recent pictures of substance abuse on a public Facebook profile, they were looking for that sort of thing. Do you guys have questions? We have a question.
Sure. So the question was on Lynn Stewart, who was the defense counsel I mentioned, that when she was first charged and prosecuted for providing material resources and support for terrorism, it was a lighter sentence, a more lenient, and then she was prosecuted for perjury and she got a stronger sentence. I want to say it was like 10 years. I think so. Yeah, okay. You're setting up the stage? Yeah, I think that's accurate. Yeah. So the question, do I feel that I could be potentially prosecuted for anything that I do? I certainly feel, I certainly hope not. I hope I haven't done anything. I joke all the time that, whether my computer systems are being monitored or my phone being monitored, that either they're doing it illegally, and if I find out someone's in a lot of trouble, or I'm in a lot of trouble. Because if they're doing it legally and it's got into that point, then I'm in real trouble. There are specific rules for the government, and I'm more familiar with them on the federal level, but I'm sure they exist on the state, local as well. There are very specific rules that are part of the policy and practice that I keep talking about with respect to lawyers and reporters. So when I was subpoenaed before the grand jury in Jeff Sterling's case, that had to have gone up to the Attorney General or the Deputy Attorney General of the United States to gain approval because I was the lawyer in the case. Same thing with Jim Rising being subpoenaed or some of the other cases recently, or James Rosen, although that was more of the records searches. I certainly expect that I have a target on my back all the time. And I've had my security clearance threatened any number of times by the government, and I've fortunately been able to turn it around in times and got some federal judges to yell at the government for trying to cause me a problem when I was trying to actually protect information more than they were. But in going back to the Sterling case, I presume the prosecutor was a very aggressive prosecutor. He was the same one on Senator Ted Stevens' case and a number of the other high-profile public integrity cases. He was a career prosecutor. I'm sure he has some politics, but he was a career prosecutor. And I am sure that it was a secondary benefit that they knew that they would be screwing me and I'd have to be bounced off the case. I don't think that that's why I was being subpoenaed, per se. I think that was just an after-the-fact smile consequence that they could do that to me. But I don't think that I'm targeted in a way that I'm concerned for my safety or anything like that. There have been times where I'm concerned from a legal standpoint, what are they going to do? We actually have my associate. We got an email on Friday from the NSA. He's supposed to be right now at meetings with the NSA on clearance cases, and we got an email saying, well, we just realized you're not barred in the state of Maryland, my associate, and that's where Fort Meade is. And we're like, well, we never heard that before. We've been going for years to appear on behalf of federal employees in administrative proceedings. It was never told to us, and I don't believe it's required to be barred in that state when you're in this administrative proceeding. But, I was in Maryland for years doing these cases before I was barred in the state of Maryland. And my colleagues who do it all the time admitted to the bar in the state of Maryland. And, why is it they're bringing that up all of a sudden? I think it's just a little jab at us to just make our life more difficult, life for the clients more difficult. So we get little things like that. But it's a very small town in D.C., and we're all very well connected, even amongst ourselves with our adversaries, especially when you've been doing it for a long time. So you really got to have someone, either you really piss them off or it's someone new politically who doesn't know you. So I guess the short answer is I'm not concerned, but I'm always paying attention.
I think we have time probably for one more question.
Anybody else?
If anybody has one?
Anything national security related?
Anybody else have a question? Yes.
Sure. So the question, if you've signed a secrecy or non-disclosure agreement, say with a private company, and then you're being pressed by the government with respect to gaining access to the information. It happens all the time, especially in the employment context. Someone leaves the employee of a private company and they left so in not so favorable terms, but they've mutually signed a non-disparagement clause. They have a written agreement that says the company's going to give you a favorable recommendation. No one's going to say bad things about each other. And then the federal government finds out about that. That document means nothing to the federal government. If you're asked a question, well, what happened to your employment here? And that's a question on the SF-86. How did you leave your last employer? How did you leave any of the employers? Under what circumstances did you leave? And then there's a drop-down menu of like 5 or 7 things. from negative to, no problems. But, you left in lieu of termination, which is very common. You're told, we're going to fire you if you don't leave, so you work out a severance package. And if you're asked by the federal government what the circumstances were, it's a crime to lie. It's a 1001 Title 18 offense. And, up to 10 years, 5 years imprisonment, $10,000 fine. Now, you can not answer the question, and you won't get the job, or you won't get the security clearance. We're not talking necessarily about a criminal case, although that could come up, obviously, as well. And, that's just a contract violation. Now, you can be sued by the company for violating the terms of the agreement. But, it comes up a lot, and especially in the national security environment where this is coming up far more often. Actually, it's been more of a problem federal government to federal government, agency to agency. One of the things we saw in Snowden recently, and though it's been somewhat disputed, was supposedly when he worked at the CIA, his managers thought, this was at least how it was reported, that he was trying to break into the computer system. And there's a memo that's in the file that says that, and that was one of the reasons why he no longer, I can't remember if he left or they fired him or how it worked, but there was recorded information that in hindsight, we look at a little bit differently. Let's see, the CIA thought maybe he was breaking into a computer system, and he went into the NSA's computer system and he took all the documents. Could we have had a little bit of foresight in that? And the NSA was saying that the government agency, or it's a private agency that does the background investigations, did not know about that CIA document because the CIA doesn't share information much of the time with other agencies, even though you're supposed to and you would think that they would. And that's part of the information sharing problem that's going on within the federal government and how that works and, what rights do you have. I mean, the basic notion is, again, to fight with folks about this all the time, most of whom are not lawyers, you're going to go work for the federal government or any government, you're giving up certain rights when you do that. You go in the military, some big case in yarmulkes. Can you wear a yarmulke? I think it was Goldberg versus whoever the Secretary of the Air Force was at the time. Because there's a dress code in that. I think he lost. I think he wasn't allowed to wear the yarmulke, if I remember. If you work for the federal government, you give up some of your First Amendment rights.
Right. Although, interestingly, and with this we'll end, that when you have workplace rights as a federal worker, at times, not in the national security context, you may also have constitutional rights in the workplace. And we see this in workplace searches and email searches that are just sort of workplace things. The courts have to decide, was a warrant needed because the employer happens to be a body of the government? So it's not simply one overrules the other, or that you have fewer rights in some contexts, but you may have constitutional rights in others, and it really is going to depend on the facts and circumstances.
Yeah, it's in the bottom line with any constitutional cases, it's going to depend on the facts. Very specific facts.
Well, once again, I want to thank Mr. Zaid for coming on behalf of the Center for Innovation, Business Law and Technology.